Speaker. That was a fairly considered and constructive contribution from the member for Rimutaka, and so I want to begin by acknowledging that and to thank him for making some fairly thoughtful observations. But nevertheless, I cannot let him get away with the suggestion that in some respects the government has been sitting on its heels in respect of this legislation, because he is, after all, a member of the party that, as far back as 2004, started talking seriously about the need for changes to the residential tenancies legislation, saying there are some really significant flaws, that's right, some really significant flaws in the legislation, and 5 years later they left office, and what had they achieved in this area? Positively zip. But we'd certainly heard a lot, they'd said a lot, but they had achieved absolutely nothing. So I have to say, Mr Hipkins, you just need to brush up on your history a little bit before you take the government to task. It is certainly fair to comment that this bill has taken just over a year from its introduction to what is very nearly its passage. But it is an incredibly complex piece of legislation, a very important bill, and it is therefore right that we have taken our time. I'm delighted that we are now in the final lap, and I just want to reiterate that there are three main purposes to the bill. The first is to encourage the development of a rental market that provides stable, quality housing to those who rent their homes. The second is that it will enable landlords to manage their properties more effectively. And the third is that it clarifies and appropriately balances tenant and landlord rights and obligations. And that's no easy task. It was important that we took our time to get it right, and I'm confident that we have. By and large, it's fair to say that the bill has enjoyed cross-party support and a very constructive progression through the Select Committee stages, and I thank everybody involved in that. As the Minister has commented when he's spoken on the bill on previous days, and other speakers, it is a very, very important piece of legislation that literally affects hundreds of thousands of New Zealanders. So, as I said, it was important that we did the job thoroughly, not rush it, but that we took our time to address the significant changes that have occurred in nearly a quarter of a century since the current Residential Tenancies Act came into force back in 1986. I'm not sure if the previous speaker was even on this planet at that time, but I'm sure that if he had been, he'd have recognised huge changes in the quarter of a century since. The bill has received very careful and thorough consideration from the departmental officials who've guided our deliberations as it's passed through the Social Services Select Committee. And, Mr Speaker, I do want to thank those officials and to acknowledge the good job that they have done. We are clearly all in their debt. They've given us very good advice at every stage along the process, and they've taken on board the many submissions that we received and have incorporated it to make sure that it is really a balanced piece of legislation. I also want to pay a tribute to Katrina Shanks, the chair of the committee, who has provided very fair and able leadership in this and indeed in all measures since she became the chair of the Social Services Committee. She's doing a very fine job, and she deserves praise for her commitment and the intelligent approach that she's bringing to that responsibility. Could I also acknowledge the contributions of my Select Committee colleagues on all sides of the House for their collective efforts to get this bill right. Because, as I've mentioned, literally hundreds of thousands of New Zealanders are affected by the provisions of this Act. And as we go further on through the years, more and more New Zealanders will come into that category. And they all depend on it to deliver fairness and to encourage adequate and ethical investment in New Zealand's residential property market. Our landlords need to have confidence that they will receive fair rates of return if they invest in rental properties, and that they will have adequate protection against that small minority of tenants who abuse their property and fail to meet their obligations. And as the previous speaker has said, all elected members of Parliament are aware of a few cases of that type, and they are very distressing for landlords when they find themselves in that position. But similarly, tenants need to have security to know that they will receive a fair deal, that their rights are enshrined in law and will be respected, and that they will have affordable and accessible remedies if their rights are abused. And that's why the bill provides for access to advice, information and dispute resolution services. It's why the responsibilities of landlords and tenants for various outgoings, such as rates and water charges, are clarified, And again, this is an area where things have changed considerably in the last quarter of a century, and we needed to ensure that the Act was updated to come into line with contemporary conditions. It's why the bill includes measures to facilitate speedy and cost-effective adjudications of tenancy disputes. And I thought I might just note how significant those changes are. For instance, the bill increases the tribunal's monetary jurisdiction, this is the Tenancy Tribunal's monetary jurisdiction, from $12,000 to $50,000. It increases the monetary threshold on the automatic right to use legal representation from $3,000 to $6,000 to ensure that legal representation is only used when it's justified, because one of the features of the Tenancy Tribunal has always been that it is accessible and that, by and large, it does not require representation for the parties. It also requires the Tribunal to order the other party to a dispute where that is the only way of trying to bring things to a head, and to compensate the applicant for the filing fee if the applicant's claim was upheld in full by the Tribunal or partially upheld by the Tribunal, and in the opinion of the Tribunal it would have been reasonable to make such an order, and I'm pleased to see that additional discretion coming into place. It also improves the enforceability of Tribunal orders by giving the Tribunal jurisdiction to make an order against a guarantor of a party to a tenancy agreement. It allows a party to recover reasonable private debt collection costs associated with enforcing a Tribunal order, and it assists Tribunal creditors to locate debtors by facilitating the release of address information held by government agencies to the District Court. And so, as I say, there are some very significant changes here. Several speakers have noted that a major initiative of this bill is the provision of protections for boarding house tenants who were previously outside the scope of our tenancy legislation. I echo the concern of others that these New Zealanders have been vulnerable to exploitation and abuse, and it's good to see them gaining some security and acknowledgement of their rights under this bill. So, Mr Speaker, I have been proud to contribute to the deliberations of our Select Committee and this House on this bill. I congratulate the Minister Phil Heatley on his successful stewardship of this bill through its third reading. It is a very significant bill and a very significant achievement for a determined and effective minister. He will certainly be remembered for this in years to come, not that I'm suggesting that he's going anywhere, and it's another significant step along the road for a focused and effective government that is delivering real gains for New Zealanders and improvements to our social and economic welfare and infrastructure, and I'm proud to have played a small part in that outcome.
Members, the question is that the motion be agreed to. Those of that opinion will say aye. Contrary will say no. The ayes have it.